Good morning. My name is Ryan Davidoc, and I'm the supervisor for the Planning, Zoning, and Land Use Unit within the Planning and Local Business Development Division here in Oakland County. Welcome to today's virtual planners gathering, the planner in court, what planners need to know. Just a few reminders, the meeting is being recorded and will be made available on our website. And if you have any questions, please use the chat function in Zoom and direct your questions to Jim Schaefer. Jim will moderate a question and answer session after the presentation has completed. So let's get started. It's my pleasure to introduce our presenters today. Today we have Jerry Fisher. Jerry Fisher's a local government consulting attorney, and he's also the author of a book called Local Government Law, a practical guidebook for public officials on city councils, community boards, and planning commissions. We're also joined by Dick Carlisle. Dick is the past president and senior principal at Carlisle Wortman Associates. So thank you both for joining us today. Jerry, the floor is yours.
All right, thank you so much, Ryan. It's a pleasure to be with you, Gerald Fisher. Ryan, thanks for plugging my book, but no, just kidding. So I will lead things off, and Dick Carlisle, as you can see, is the power hitter here. He'll bat cleanup after I'm on first base with a bunt, but in fairness to Dick, we have to know that when he goes for the mighty power swing, that he makes contact with the ball. So we can go to the next slide. So let's start right off. We're talking about planners serving as witnesses and becoming involved in trials. So what kind of cases rationale for the denial? The second type would be where the challenge to a zoning ordinance provision as it applies to the property. So we have an existing zoning provision. The property owner is not happy with that provision, so he challenges it. Now, the other type of challenge that could be made is a challenge of the ordinance on its face. So if the ordinance, for example, is not adequately supported by the Zoning Enabling Act, there may be a challenge that the ordinance itself is invalid. The case is filed by the property owner when a special land use. So this is getting into typically administrative actions where a special land use is denied or other discretionary use. And a PUD can be, in Michigan, can be either legislatively approved or administratively approved. And they have various ramifications then with regard to what a trial would look like in a case like that. The other possibility would be where a property owner is challenging the denial of a variance, and that the planner is really important in that case where the ZBA has relied on the planner's report. And again, the planner will be a star witness. And so you can see that in 2 out of the 4 here, the planner is the star. So that's, in other words, the planner is very important in these kinds of cases. Okay. There are 2 types of witnesses that may arise and may appear in a case. The planner is typically one of these, but not both. So the fact witness is a witness that gets on the witness stand and is asked questions. What did you see? what did you learn from this, etc. And that would be just stating facts. The expert witness, and the planner is generally an expert witness in these kinds of cases. Um, the planner will build on the facts and then draw a conclusion by applying his or her expertise and experience. And so that's really the fundamental difference, is that the planner then will be drawing conclusions. And as you could imagine, that's where the cross-examination will come in, that the planner has drawn these conclusions that that are going to be challenged in terms of, well, why did you say that? And on what basis did you draw that conclusion? And so forth. So this is where the planners are earning their keep. In a controversial case, the planner is going to be preparing a report, generally speaking. And when you prepare the report, one of the things that you want to pay close attention to is the idea that you may be cross-examined on the words that you have selected. I mean, it'll certainly be the conclusions you've drawn, but even the words that you have selected. Let's just take an example. I mean, a judge may be entirely unfamiliar with the concept of transitional zoning, say. And so if the case involves denying a heavy commercial use that happens to be next to a low density residential use, the planner may want to explain the concept of transitional zoning. And I know that if you want to ask questions, I mean, some of you may want to know what transitional zone. No, I'm just kidding. All right, and so the other related question, you're doing your report, and the question is the report subject to a FOIA request, and probably later on then subject to a subpoena. And so you can basically understand from general concepts involving FOIA and involving subpoenas that you can FOIA materials that are not covered explicitly in the statute as an exemption from documents from public records that are subject to FOIA. And in this type of situation, it seems to me that the only time you could shield the planner's report is if they are in the process of working with the attorney for the local unit of government on developing their legal theory. But once that theory is in place, the planner's report is going to be subject to both FOIA and subpoena. Can opposing counsel ask about discussions and emails that the planner is having with legal counsel? And again, it's going to be based upon whether or not the attorney-client privilege is going to apply. And as you are exchanging emails, having discussions, you should assume along the way that your email is going to be presented to you on a sheet of paper when you're on the witness stand so that you can explain it. And so, I mean, that's just kind of an assumption you should make. Is there a problem if you've made a recommendation in a case and it's not followed? In other words, your recommendation is to approve and the government denies it. So what can you do in this case? I think the thing that you want to think about is to anticipate this possibility in almost every circumstance, because you never know when the township board, city council, village council, or etc., a planning commission will follow your recommendation, even though it's undoubtedly perfect. But one of the things that you learn to do is, again, choose your words wisely and learn to hedge your bets to some degree. In case you get into this exact situation, you'll be able to say, yes, I mean, this This was my primary thought, but depending upon the facts, it can go the other way. So again, controversial cases. If you're the planner representing the property owner, and you may be called as a deposition witness. Why would the opposing attorney want to take the planner's deposition? And the key is to find out just how strong the planner's position is. Is it substantiated by good planning theory? Is it substantiated by the law? And if it's very strong, the attorney on the other side may find the need to hire another planner on his or her side in order to counter what your position is. The other idea is to avoid surprises at trial. And believe me, that the last thing in the world that the lawyer wants to do in a case is to get caught with a gotcha moment where because you have to admit something, it's going to destroy a case. And so, depending upon what's disclosed, again, the attorney may want to modify the case, which is possible when a deposition is taken. They can amend their pleadings and things like that. And so they want to know what's going on so they don't get caught in the gotcha kind of thing. And here's a tip that is really important from a practical standpoint and may have some serious legal ramifications. So when you're called as a witness for deposition or trial, the attorney on the other side is going to ask you a series of questions. And what you want to do is answer those questions, and only those questions. You may have a strong urge to think, well, let me help you understand here. You obviously don't understand everything. Let me help you understand what's really at stake here. In other words, you have good intentions, but that may unwittingly be the undoing of your case because, the lawyer on the other side may not understand all of the ramifications, and you will be tipping off the lawyer of some other opportunities that they will go into with questions. And there may be more questions that follow the line of what you have opened up than they have with their original questions. So the idea, the bottom line here, don't volunteer. Now, if you have these brilliant strokes of ideas during the deposition or trial, what you want to do is make a quick note of it and then speak to your legal counsel about it. And your legal counsel may want to put you on the stand or examine you directly with regard to that issue, or in some other way address it. But that way, you're not going to be tipping off the other attorney. Now, of course, you're saying to yourself, "Well, wait a minute. I thought that a trial was being conducted to get at the truth." And let's put truth in quotation marks here, because the reality is that the legal system operates based upon a set of rules that have developed over many years, and generally speaking, the rules have developed to make it more likely that the evidence presented is reliable. And so what it comes down to at the end is the truth is what is demonstrated at the end of the trial within the framework of the rules. And so you have to live with the rules and be careful, for example, not to volunteer information. So one of the rules, speaking of rules that are kind of designed to bring about reliability, would be the hearsay rule. And you've heard about this many times. So let's assume that you're on the witness stand and or maybe taking a deposition, and you've been asked a question, you start answering, and all of a sudden the lawyer says, "Just a minute here, just a minute. I'm going to object to this question on the basis of hearsay." Well, what is hearsay? Essentially, hearsay is where you have a witness, or your statement is basically second-handed. It's not based upon your experience directly, but you are passing forward a statement that somebody else has made. So the important question is, who has made that statement? Is it a party or a non-party? Why is that important? Because if it's a non-party, that statement may never be subjected to cross-examination. That's the key to looking for reliability. That's one of the rules to achieve reliability. If it's a party may always be called by the other side, in fact, called by either side, and may be cross-examined to determine the reliability of the statement. So that's the hearsay rule, and it's a good rule. There are many, many exceptions to the hearsay rule, but that's one of the primary points involved here. So the last point that I'm going to get into here, and it looks like I'm pretty close to being on time, is what happens when a reporter, a member of the press, calls you in a very controversial case. And this can happen just kind of out of the blue. You get a call, can be tricky, and they ask you a question that is not in your report. Now, if the question relates to something in your report, you can go ahead and answer it very easily. But the danger, if it's not in your report, is, number one, you don't know how important this point is. Number two, you don't know what the correct answer is to the question, or you may not. I mean, it may not be that obvious. And if you give your opinion, you may be opening the door to trouble for your client. So, I mean, in some cases, the reporter is calling you right after talking to the attorney for the other side, or the party for the other side, and kind of, again, asking you to volunteer some things that may hurt your case. So what's the best advice? Sidestep the question and not answer it. And so that's we could go on for a couple of hours in this area, but these are some of the highlights that hopefully will give you some assistance and help you understand the system a little more so that you can be effective within that system. Dick?
Hey,
It's all up to you.
all righty. I'm assuming that I had to switch devices because Jerry's presentation was so powerful that it blew up. Just amazing, Jerry, once again. So Jerry did a really great job of laying out some of the fundamentals of testifying. Did explain the difference between a fact and expert witness, but some of the same rules apply no matter what capacity that you are serving as. I mean, generally, if you are a planner working in a municipality and you've written a report, it's highly likely at some point in time you're going to be called as a fact witness on a land use case. An expert is someone who's hired that is knowledgeable and well informed on a particular subject matter. And as an expert, you are to provide that expertise in an impartial manner, and the purpose of which is to provide a factual and impartial basis for a judge or jury to make a decision. Obviously, an expert is hired by one side or the other, and is there to try to present the most favorable light of their case. But as we go on, you'll see that there are certain circumstances where you either should or should not sign on as an expert in a case. Let me tell you, I'm not going to lie. Even after having been an expert witness in probably over 125, 150 cases, it's an intimidating experience. There's no question about it. we're used to commonly expressing our knowledge and opinions in the public arena, and and many, especially these days, definitely, receiving some criticism of that from the public many times. But in litigation, your testimony, your opinion, and your credibility is going to be challenged by the opposing counsel, who will do what they can to undermine your opinion and credibility sometimes through intimidation. Now, Jerry never played tricks on anybody. I know that for sure. But cajole you into saying something that is going to be favorable to their case and damaging to the side that you may be testifying on. So that's part of the experience. And if you're going to do testimony, you should be used to that, and don't have a thin skin about it. So Jerry, I think already explained pretty well why planners are called to testify. Well, first of all, we are the most knowledgeable people about the master plan, especially if we were involved in preparation of it. Not just understanding what the plan might say or exhibit, but the process behind the thinking of the plan. Because, generally, if there's a logical process, and Jerry could comment further, but, the courts have given credibility to the fact that there's a rational basis to a plan, and if it's well thought out. And I think this is a benefit of the revisions to the Planning Act, that communities are required to update the plan, or at least to consider the plan every 5 years, because it's a lot easier to defend an up-to-date plan than it is one that hasn't been updated for 20, 30 years. And I've been in that position before. You're also, knowledgeable about zoning regulations, and particularly how those regulations advance a legitimate governmental interest and the protection of public health, safety, and welfare. That's the basis of zoning. And if you are on the stand to explain how those regulations relate to those key factors. Also, procedures. There, frequently, as Jerry explained, there's procedural issues that may come up, and planners are able to explain how they were followed in a specific case, and how they were followed consistently with how other cases of a similar nature were treated, and how the foundation of planning and zoning is established in both our Michigan Zoning Enabling Act and the Planning Act. You should be an expert, whether you're a fact or an expert planner in a case. You should be an expert in the substantive provisions of both acts. Now, what happens before you agree to testify? First of all, if you're a fact witness, you generally don't have any choice. You're going to be subpoenaed, you're going to have to testify, and you're testifying as to the facts of the case. But if you're an expert, you don't have to serve as an expert unless you choose to do so. Do not agree to serve as an expert witness unless you become familiar with the case. And it's got to be something that you're comfortable with supporting the documentation that's in the complaint to determine if your expertise matches the facts of that case. There's been a number of times where I didn't feel comfortable, and I had to tell opposing counsel, look, this isn't something that I feel comfortable testifying about. So you definitely need to understand what the case is about before you agree to testify. Otherwise, you might find yourself in trouble as you begin to prepare for the case, and your name is on that witness list, and you've agreed to testify over a case that maybe you don't know very much about. You should also know who is the opposing counsel, because you want to know what their background and style is, and if you have any potential conflicts. In other words, maybe you've done work for this opposing counsel before. I'm not saying that necessarily is a conflict, and sometimes it can be a benefit to you if they've hired you as an expert in another case, that it's pretty hard for them to question whether you are an expert or not if they've hired you as an expert witness. But you definitely want to know what their style is and whether you are comfortable, because if you're aware of a pretty aggressive style, you better be prepared for that in testimony. Conversely, you better be comfortable with your own legal counsel style and approach. obviously never had a problem with that with Jerry, because Jerry was always highly prepared, and as are most attorneys that I've worked with. But occasionally you will have a legal counsel you're working with who your style and their style just don't match. And you want, while they cannot direct you what to say, they certainly can provide you with helpful facts about how you should craft your testimony. Just remember, as Jerry said, you have a record. And your record is going to be scrutinized, especially if you've testified both for and against municipalities. A number of years ago, I was testifying. In fact, Jerry, I think, was the attorney, where I was being questioned by opposing counsel, and he started asking me about a presentation I'd given at a planning conference 5 years before that. And out in the hallway, I said to him, I said, "Man," I said, "how did you remember? I don't even remember what I said then." He goes, I said, "How did you remember what I said in that presentation?" He smiled at me and looked at me. He goes, "It's my job." So it is their job, and so understand that everything that you've done in your past record is fair game. Also have an understanding, if your legal counsel wants you to write a written report. I personally prefer that because it helps me organize my thoughts. In some cases, they may not want a written report because of expenses related to the case or other reasons. You have to understand the schedule of the case. It's unpredictable. Make sure your legal counsel has a clear understanding of your availability to avoid any conflicts. Like when you're unavailable, when the times that you may be on vacation and or have other conflicts. So and then finally, if you are serving as an expert, be clear about your expectations for compensation, and have it in a written agreement. You are, as an expert, you are entitled to fair compensation for the work you do, and it's because of the nature of the work and the rigor and the responsibility associated with it. You want to make sure that your legal counsel knows what you expect to be compensated for that case. Jerry put this well. When you do agree to testify, recognize your expertise and stay within it. Don't go veering off into an area that you're going to be questioned about and that you don't have expertise. Just stay within your expertise. The simple advice for this is just simply don't do it. Stay within your area of expertise. Your obligation is to be prepared and collect whatever reports, data, etc. Your counsel should, and you should expect them to provide you with case information. You don't want to be surprised by a document that you haven't seen before. And so consequently, it's a good idea to be on the same page with the counsel that you're working with to make sure you have all the relevant information. Otherwise, you're going to, it's a good possibility that you might be surprised in testimony. So be careful about that. We can move on.
I did, Dick. Go ahead.
There we go. The timeframes are important. When draft reports are due, you don't want to be the reason to miss an imposed court schedule. That would look very bad for your credibility. You don't want to be the reason why documents are not delivered on time. Make sure you understand what it is you're supposed to be doing and when you have to have it done by. Don't work up to the absolute deadlines because you want to give your legal counsel time to review your draft report. So be on time. This is a court-imposed schedule, and you don't want to be the reason why you develop a bad relationship because you've made your legal counsel look bad in the eyes of the court or his client or her client. Use concise language. I know we have a language of our own, but remember, you're trying to provide factual information to people who are not zoning experts, the judge, or jury. If it's a bench trial or it's a jury trial, you got to explain things in a way that people are going to understand it. So try to minimize, planner's language to the extent possible. Preparation be key. Don't wing it in court. I've seen it happen. It's disastrous. You have to be prepared. As Jerry said, try to keep don't make an extensive explanation. I know we try to be overly helpful as planners. That's kind of, we were trained to be that way, but don't offer more information than what was asked. You'll just get yourself in trouble, and you'll go down a rabbit hole that you might not be able to climb out on. Try to simplify. I had a sort of a rule where I tried to simplify testimony, even in complex cases. It helped me organize my own thinking. So I tried to distill my testimony to 3 or 5 main points and be able to amplify and expand on those points, because I knew I could always go back to those, even if I was asked a question that was when opposing counsel is going on a fishing expedition. And as I say, they will, and you should not take the bait. That's a tactic that you need to be very careful in allowing opposing counsel to venture out into. So it is definitely a tactic. Another key tactic is hypothetical questions, which may or may not be relative to the case. Again, it's a fishing expedition. Don't answer a hypothetical question and press for more clarity. In fact, if you don't understand a question, don't answer it. Ask for clarification, because sometimes wording is intentionally obtuse and meant to trick, the witness. So always ask for clarification if you don't answer the question. There's no penalty in doing that. Don't answer the question if you don't understand it. And oftentimes what happens when opposing counsel rephrases the question and it's maybe still, abstract or not understandable, by the third time, you've kind of worn them out and they may not even follow up with another question. And sometimes they may be admonished by the judge to move on too. Compound questions are another popular tactic, where it's a two-part question, which could elicit a conflicting response. Don't avoid responding, and point those out to break the question down into two simple questions. And finally, I think Jerry did mention the fact that your record is both spoken and written is definitely part of fact finding and part of discovery. So, be careful what you say on social media. Be careful that be aware of reports that you may have written on similar cases that may have conflicting opinions, because your entire record will be examined before you testify. I can almost guarantee that. Your phone records, your text messages, your emails, and any written communication that you have in terms of reports. Yes, as I've said, and as a final note, your testimony is sought as a professional. So, speak professionally, act professionally, dress as a professional. I have a theory why Jerry wears bow ties, because I think he does it to intimidate opposing counsel, because they're trying to figure out how he actually ties that thing. I mean, I've never been able to do it myself, but I think that's why he does it. I clearly think that's the case. But you're there, representing a municipality or a private client. You may be either side, and you want to represent them in the best light. So it's always a good idea to wear business clothing and dress professionally. And I think that is the conclusion of my part of this program.
Excellent. Thank you very much, gentlemen. Very good. We're a little ahead of schedule, which is great. First question, can you delve a little deeper into what constitutes something that's discoverable under FOIA versus exempt due to attorney-client?
I think Jerry's probably better answering that question.
Yeah. Essentially, under FOIA, all public records that are used and on file at the local government are fair game. And it may extend a little further out than that with regard to attorneys, because there was a case involving the city of the village of Clarkston a couple of years ago where the Michigan Supreme Court said, documents on file with the attorney that belong to the city are also subject to FOIA. So that's something to be careful about. But so to finish answering your question, the FOIA statute has a series, a growing series of exemptions that are recognized that should not be the record should not be disclosed. And so, for example, one of the most common that would arise in the subject matter that we're talking about here would be documents that are subject to the attorney-client privilege. And and the attorney-client privilege is going to go only so far and only cover matters that are relevant to the attorney's work product and confidential advice to the client. Well, so the attorney could write an legal opinion. The legal opinion could have matters of fact and also opinions of law. The only part of that document that is exempt is the opinion part. So merely stating facts, unless those facts somehow would lead to a disclosure of the legal theory, which is unlikely, the local government has to redact the legal aspect of it and disclose the rest. And so let's say now we're getting into the realm of planning. At the beginning of a case, a lawyer may be having a discussion with the planner with regard to what is the best way to put a case into evidence so that it's favorable to your client and still fair. And at that point, an argument could be made that you're still the attorney is still developing a legal theory, but generally speaking, the privilege of a lawyer with a local unit of government client applies to the advice and communications that lawyer is having with that client. Though the client would be maybe the in-house people, maybe the planning commission members, maybe the city council, township board, etc. But once a document is sent to a third party, it loses its privilege because it's no longer attorney-client privilege. It's attorney to attorney or attorney to some other third party. So that really kind of lays out the parameters of at least that I'm thinking about at the moment. And you may have a follow-up question, but that really gives some idea of the parameters of a document that is going to be subject to FOIA.
Okay, excellent. And for participants, please do send questions directly to me in chat, and we can get them out. The discussion about personal posts, can you elaborate a little bit on that? Does that mean that my personal posts on social media, testimony at meetings, etc., can all be used against me as an expert and as a factual witness?
Dick?
I was going to, my understanding is generally yes. I mean, because, you're expressing, a position over a public media, which for all to read, and absolutely, that's part of your, it's part of your record and definitely can be brought up in testimony. Same thing with, text messages, even, casual text messages to a client that's relevant or even not relevant to the case sometimes become part of discovery. I mean, to me, the most, and maybe Jerry can comment a little bit more, the most difficult one for me is telephone conversations. I personally keep very few notes of telephone conversations, but perhaps, the person on the other end may well have kept a record of our phone conversation. And that's all for me in terms of discovery. That's been one of the more difficult things. Written communications, even emails, less of a problem. But the thing is it does create, I mean, especially for cases where you have to go back through a period of time to research your records and your emails and your text messages it's very difficult sometimes because sometimes we've had many cases where we've had to bring in our IT consultant to actually help us do that because retrieving some of those things is very difficult. But here's the problem. You never know when the other side is going to have those communications because they may have subpoenaed those through discovery with your client who may have a record of those either conversations or those emails. So, when in doubt, you provide all of the information to your legal counsel, have them review it, and let them determine what's relevant and what's not.
Yeah. Yeah, and I can just tag on to one point here that Dick alluded to, and that is if you are texting, the typical thing is that you may erase texts, and get them out of your device. You think you're getting them out of your device, but as Dick mentioned, very often an IT person can find those texts. They're probably there in your system, and it's very difficult to get them out of there. Not that you're going to try to hide anything, but if you erase things, don't think that they're gone. They may still be available.
Well, and Jerry, that brings up a great point because text messages, can be really like poison because we all use more casual language, through sometimes email and frequently through text messages. And, when you're operating in the type of environment that we are, and particularly when it's related to a specific development matter in your community, just remember that if that ever goes to litigation, you want to be very careful about what you put in a text message. There was a case a number of years ago in a community, and I will not indicate who it was, where the elected officials were at the dais were texting about audience members, making somewhat critical comments about people's comments in the audience. And that particular case ended up it was very embarrassing, obviously, because things were said about people in a public environment, people just, speaking in public. And for the public officials, it was pretty embarrassing that the fact is they were sitting at the dais, making derogatory comments about people in the audience. So, it's, caution is the word, I'll tell you.
Yeah.
Okay. You had mentioned, and this is to Dick, you had mentioned that when you work as an expert for opposing counsel, does that exempt you? Can you elaborate a little bit more on that and the pros and cons that might face? And also, is there an issue with that for factual witnesses?
Well, first of all, I know there's been many circumstances where I did know opposing counsel and felt perfectly comfortable testifying in the case. There were some circumstances where I did not feel comfortable because of close personal relationships with opposing counsel. The one particular rule that we have always had is to avoid testifying against municipalities because it's just, when you represent as many municipalities as we do, it's just way too difficult to opine about something in a particular case where you may have advised another community, in the exact same manner, and it's on record. So, we've confined our testimony, to just working with municipalities over the last number of years, because then you really avoid a lot of conflicts of interest from that standpoint. I've seen it happen where you have experts that opinions really that they've expressed elsewhere, become a substantial factor in the case, in particularly in their testimony, because they've advised one community to do one thing and then are testifying against the community for doing pretty much the same thing. So, you have to be very careful about that because, again, all that you do is part of the record. So from that standpoint, but no, Jim, I think what I mentioned is, there have been many times where I knew opposing counsel, and may have used me used me as an expert in another case. And I said, in that particular case, it's pretty hard for them to claim that I'm not an expert in that particular. I'm not a particular expert because they've used us as an expert elsewhere. So,
Okay. Um, any general advice from both of you on a planner that would want to move into the area of providing their services as an expert witness, and that would be actively employed planners and then retired planners?
well, I mean, first of all, I mean, be aware of what you're getting into. I mean, be clear that, um, it is challenging work. There's no question about it, and be confident in your ability to, you know, provide your planning expertise in probably one of the most stressful settings that you'll ever be in a court of law. Uh, I don't want to minimize how potentially intimidating it can be, because it can be. Um, but by the same token, I think you should have confidence in the fact that, planners know more about planning than anybody else in that courtroom. If we didn't, we shouldn't be doing what we're doing. Um, you know, Opposing counsels, and the system is made up of people that are not experts in planning. That's why they hire planners as experts in these zoning cases. Uh, but be comfortable, with your ability to carefully articulate, you know, how, from a planning perspective, that is brought to bear on any particular case, recognizing that your opinions are going to be challenged.
Okay. Jerry?
Yeah, yeah. I think, I mean, there's certainly no a substitute for preparation. The most important thing is, if you're thinking about being an expert witness and offering your services in that area, whether you're retired or actively practicing, is that you want to make sure, and I think Dick said it very well, is that you want to know the Zoning Enabling Act and Planning Enabling Act inside out, to the extent that you are able to do that. And then when you get involved in a particular case, uh, you're going to have to study a lot to get ready, and you may not be compensated for 100% of that study. I mean, because a part of it is just getting yourself ready, rather than preparing for your particular client's issue. So be prepared to make those kinds of sacrifices. But you always want to be as prepared as you can, to before you write a report or get on the witness stand and so forth. And once you get there, once you get on the stand, and you've been thoughtful about being sure that your points are going to be cross-examined, and you can always assume that cross-examination is not going to be pleasant. But here's the thing: do not take it personally.
Yeah.
An attorney is going to want to lead you down the path where you are going to be putting your personal credibility on the line, and then they're going to beat you up. If they've caught you in a situation where your testimony can go one of two ways, and you've decided to take the one way, and they're going to beat you up on that. Don't take it personally. I think the best advice I've ever given in this area, both to lawyers and planners, is whatever you're doing, have fun doing it,
Yeah.
because that is going to keep your attitude on the right road.
Right. One other point about this, Jim, is that in regards to preparation is, read about case law and read about, there are some obviously landmark cases that have been relied upon in terms of case law to build the credibility and the legality of zoning. Understand those, okay? And one of the references here I'm going to do, but plug in another one of Jerry's books, but the Michigan Planning and Zoning, which Jerry and a number of other very fine attorneys, write every year for the Institute for Legal Education. Have your current copy of that and refer to that. To this day, I refer to that publication, many, many, many times a week. When somebody comes to me with a question, I go back to that because the legal basis for literally everything that we do as planners in Michigan is in that book. I think if you have a thorough understanding of what's in that book, you're going to have much better preparation to become either both a fact or an expert witness. Understanding the fundamental basis behind public health, safety, and welfare, and advancing legitimately, that may sound like abstract terms, but they're not. They're very concrete terms when it comes to whether courts uphold a regulation or don't, whether it advances a legitimate governmental interest and is designed to protect public health, safety, and welfare. You can't explain why that's the case. You should not be an expert witness.
Okay, excellent. We do have another question that just came in. Are handwritten notes made while you're working on a report also a part of the public record?
I'd
Yes.
say, yeah, if they're still available, the answer is yes.
Yeah.
I mean, if the notes have been thrown away, you can be questioned on what's your best recollection of what your notes were?
Okay.
Because they're notes that you have prepared. They're not based on a statement of some other person that's not a party to the case.
Okay.
And Jim, handwritten notes, like on a site plan that you've reviewed. And many of us over the years, reviewing a site plan, you may have made comments on an actual plan itself. I mean, if you have that in your files, that's potentially discoverable.
Okay. All right. I am seeing no other questions. So Ryan, I'll turn it over to you.
Yeah, so I just wanted to thank Jerry and Dick for joining us today and for providing their insights and expertise. Also want to thank all of you for joining today, and I look forward to seeing you at our next planners gathering on June 24th. We'll have a presentation on emergency management planning and site design for people with disabilities. So again, thanks for joining today. Have a wonderful day, everyone.